Hey, Todd Halleck here. Thought I'd talk to you a little bit today about real estate and how we hold title to real estate and how that affects us when someone passes away. We've talked in the past about probate and what probate means. If I hold a piece of real estate, say my home, for example, is a common one that most people own. If I hold that real estate in my personal name at the time of my death, that will likely have to go through a probate process. And in many states, it doesn't matter what the value is. If you hold real estate in your personal name at the time of your passing, that will have to go through a probate process. So what are some ways that people try to avoid having to go through probate, and what are some ways we hold real estate and what's the effect of that on whether or not we have to go through a probate process? So like I said, if I just hold it in my personal name, that's almost certainly going to guarantee that there will be a probate. What if I own that real estate with someone else? Well, there's a couple of different ways normally, there are some exceptions to this, but a couple of different ways normally that people hold real estate with someone else. The first is joint tenancy, or sometimes heard of as joint tenancy with rights of survivorship. The other is tenants in common. What's the difference between those two? Well, it's in those words, with rights of survivorship. And it's important to know that depending on your state, they may require that specific language in the deed, especially if we're dealing with two people who aren't married to each other. Some states, like my own, they presume joint tenancy with rights of survivorship for a husband and wife, but that's not always the case in every state. And it's certainly not the case if it's two or more owners. So let's talk about tenants in common in the first instance. So let's say two brothers, Bob and Tom, own a farm together. Bob here, Tom here, and here's the farm that they own together. So then they own it as tenants in common. And so what happens if Tom decides that he wants to leave the farm, doesn't want to own it anymore? What could he do to terminate that relationship while he's alive? Well, one, he could sue Bob for what we call partition, and then the courts will either break up the farm and give each of them a portion, or they will force the sale of the farm and divide up the proceeds. So that's one thing that can happen in a tenants in common situation if there's no agreement to the contrary between the owners. So what happens though if Tom passes away? Now what happens? Well, because it's tenants in common and not joint tenancy with rights of survivorship, the first thing that'll happen is we'll have to go through a probate for Tom, and his half of the farm will have to pass through probate and either pass to his heirs or pass to his beneficiaries under a will, if he's done one of those, according to that probate process. And depending on the state, that may take quite a bit of time and may be quite expensive, but it will have to go through a probate process. And now, let's say Tom didn't have a will, and let's say Tom wasn't married, but he has 3 kids. Well, now his 3 kids are co-owners with Bob of that farm. Probably not what Bob or Tom probably intended. Again, they also have those rights of partition that could allow them to force a dissolution and a sale of this property. So not a great result. Tenants in common, usually not the best way to go about holding real estate together, especially if it's in a business situation. Let's look at what happens in a joint tenancy. So we've got Bob and Tom again, and they're joint tenants in this thing. And same rules apply with respect to partition. So we've got all those same issues. But what happens when Tom dies is that Bob becomes now the sole owner of that farm without any requirement of compensation to Tom's family or anything. Again, while that's maybe better for Bob at the end of the day, it may not be the results that Tom was intending. And again, like I said before, all those partition rights are still there. So what are some ways that we can address this without having to go through the probate process? Well, one thing we can do is with the tenants in common or the joint tenancy arrangement to try to stop partition, one thing we could do is look to have a tenants in common agreement or a joint tenancy agreement that prevents that kind of partition from happening. You could also look to putting this operation, this farmland, into a limited liability company that would then not necessarily need to pass through probate. Other things that are available when we're dealing with real estate, if we want to avoid probate, is what we call a beneficiary deed. Some states, the states that I'm licensed in, 2 of the states I'm licensed in, allow what we call a beneficiary deed or a transfer on death deed. And that's where you, as the owner of the real estate, actually identify and record at the county recorder's office who the beneficiaries will be at the time you pass away of your interest in the real property. You can do that if you're the sole owner. You can do that if it's tenants in common. If it's joint tenants, though, that joint tenancy will override your beneficiary deed. So it's really important to understand what's going on there. Oftentimes I get folks that want to avoid probate, so they'll throw a son or a daughter on as a joint tenant, not realizing that now that son or daughter is going to get the whole thing when they pass away. That son or daughter may or may not be able to transition shares out to the other kids, and they may not be willing to do so. And above and beyond that, as long as that son or daughter is on title, if they end up with any problems, they themselves could end up, or their creditors could end up attaching their interest in the property and creating all sorts of problems. So using joint tenancies as a means to avoid probate works pretty well for a husband and wife, but anything beyond that tends to create some real problems. Had a situation once where family didn't realize it, but they had it on there as joint tenancy, and as each child was passing away, their family was losing their share of the farm, not what they intended at all. And so got to be really clear about what your goals and objectives are. In my opinion, the absolute best way to handle ownership of real estate in an estate, whether it's in an investment kind of real estate or whether it's a family cabin or a personal residence, is through the use of the living trust. This allows us to avoid probate. It allows us to establish a clear scheme of how things are handled upon the death of the owner. It allows for someone else to come in and manage that property if that owner is incapacitated or unable to manage their affairs, and not subject that property to that person's debts and liabilities. If it's an investment piece of property, we'd also add in the limited liability company that I mentioned earlier. That way, if we want to do gifting and things like that, we're doing it in a way that does not fractionalize ownership of the property. So be careful. If you own property in your own personal name, if you own it as joint tenants, as tenants in common, you've got some potential problems, either in the form of probates or unintended consequences, or maybe new owners that you're getting in that you weren't thinking were going to be part of your ownership group. These things are things that we can plan for, we can take care of, but you have to want to do it. You have to want to do the work to get it done. Sometimes make some hard decisions. Don't just leave this stuff to chance, because it can blow up and cause all sorts of family problems. That's a little bit about planning, estate planning with real estate. Hope that you found that helpful today. If you did, please like and subscribe to this YouTube channel and give us some feedback. We'd love to hear from you.